Nevertheless, I do not believe that the relaxation of the locus standi rule was meant to act as a carte blanche for any stranger walking along the streets and who is not even a member of a given group or entity to continuously and constantly shop around by peeping through fences or over perimeter walls with a view to eavesdropping on the internal affairs of such group, and where he deems that violations against members have been committed, rush to court with constitutional petitions allegedly for and on behalf of such members, particularly where such members have themselves not complained. That can only be allowed in cases of criminal law, and which in any event are to be reported to and handled by the police. My view is that a person who seeks to litigate against a given group of persons on the basis of violations of constitutional rights ought to demonstrate some level of nexus linking him to such group, particularly where there is no evidence that the members have requested the purported public-spirited litigant to approach the court with a constitutional petition on their behalf. Article 22 and also Article 258 lists the categories of people who can invoke the provisional constitutional provisions. 1, a person acting on behalf of another person who cannot act on their own name. A person acting as a member of or in the interest of a group or class of persons. A person acting in the public interest, or an association acting in the interest of one or more of its members. It is therefore clear that a person who approaches the court for enforcement of the Constitution must demonstrate that he falls within the categories set out in the 2 articles. Then in respect to membership, I've looked at the constitution of the first respondent, and it sets out as follows at Article 3, any Muslim of either sex shall be eligible to become a member of the association. Article 4 provides that every member shall pay a subscription of 100 shillings per month. Article 5 provides that no member shall be entitled and allowed to vote at any meeting of the association or its committee if he shall be in arrears of his monthly subscription for over 3 months. Article 6 stipulates that a member whose subscription is found to be unpaid for the period of 6 consecutive months shall be required in writing by the honorary secretary to pay the same within 7 days, and if he fails, he shall automatically cease to be a member of the association. It is therefore apparent that inasmuch as membership of the association is open to any person professing the Muslim faith, such membership is still subject to one paying monthly subscription fees. Accumulation of arrears in subscription denies a member the enjoyment or exercise of privileges available from the association, and accumulation of 6 months arrears renders one liable for outright disqualification from membership. In his petition, the petitioner did not disclose or state whether he is a member of the association. However, when he was being cross-examined during his viva voce testimony, he insisted that he was a member. He conceded, however, that to be a member, one was required to pay fees. He, however, readily admitted that he has never paid a shilling in subscription to the association. On his part, the secretary to the association contended that they have never received any application from the petitioner seeking to join the association. Under these circumstances, I safely conclude, as I hereby do, that the petitioner is not a bona fide member of the association. Not being a member of the association, can the petitioner still validly maintain the present petition, considering the nature of violations alleged? I do not think so. My finding is that as long as the petition raises questions regarding internal matters of the association, such as conduct of elections, audit of books of account, conduct of general meetings, release of information to members, custody and management of properties, and such like matters, in my view, the petitioner cannot validly advance the petition. By their very nature, the matters raised are privilege available only to members of the association. They cannot be available to any stranger outside the association. Not being a member, therefore, the petitioner is one such stranger. He cannot, therefore, competently maintain the petition. I agree the respondents' counsel that the right to freedom of association is not absolute and is only exercisable within associations or communities to which one has subscribed or is a member, and that this right does not guarantee freedom to non-members or strangers to interfere in the ongoings of an association. There are other matters that were raised. Just read out the relevant ones. Yes, there is also the issue of whether the second to ninth respondents are even the right persons to have been sued to answer for the alleged violations by officials of the association. In the petition, the petitioner has described the second to ninth respondents as committee members and as also trustees of the association. It is strike law that a society is not a legal person capable of being sued or suing. For this reason, a society is sued through its registered officials. The petitioner exhibited a copy of a letter from the Registrar of Societies in which 5 people are listed as officials. It is not lost on me that out of the second to ninth respondents, only 4 appear in the list furnished in the letter from the Registrar of Societies. There is no explanation from the petitioner on why he has sued the first, second, third, and 8th respondents as well. I also note that the Secretary exhibited a copy of another letter from the Registrar of Societies, which gives the names of the office bearers as Mohammed Haji Isaac, Chairperson, Mohammed Shumo, Secretary, and Yusuf Jama Abdi, Treasurer. Again, from this list, only Mohammed Haji Isaac has been sued. The Secretary has also exhibited minutes of the AGM meeting of the 10th April 2021, 3 months before this petition was filed. The minutes contains a list of the officials elected on that date. Save for Mohammed Haji Isaac, the persons said to have been elected at the meeting as committee members and those elected as trustees are totally different from those who have been sued herein. When asked during cross-examination why he did not sue the registered officials, the petitioner responded that he does not recognize them as they are